Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Welcome to another episode of Empowering Plans with the FIA Group. My name is Cindy Merrell, and today I'm joined by Bryan Dunton. Say hi, Bryan.
Hi, everyone. Nice to be back.
I'm really excited about today because we're going to talk about the No Surprises Act, which, unlike its name, has had lots of surprises. So I think this is a really good topic, and Bryan had suggested this because there's been a lot of conversation. We just talked briefly about this last week, but there's been a lot of a conversation, and it's evolving. But whenever things are evolving, which is usually a good thing, we need to sometimes stop and look back to where we've been so we can better evaluate where we are with this. And many of you may know a lot about the No Surprises Act, but some of you may not. So we're going to start with the beginning. The No Surprises Act went into effect back in 2022, and it's usually described as a patient protection law, and that is still the right starting point. The law was designed to take patients out of many surprise billing disputes for emergency services and certain out-of-network services performed at in-network facilities. So a good example of this is if I was having a gallbladder surgery and it was a pre-scheduled surgery, the hospital and the surgeon are in network, but for whatever reason, my anesthesiologist is out of network. This was designed to protect patients. But the law didn't eliminate the payment dispute. It moved the dispute away from the patient and into a new forum. And that forum is called the Federal Independent Dispute Resolution Process. And we refer to it as the IDR process. The patient may be protected from balance billing, but the fight over the ultimate payment amount is still very much alive between the payors, the providers, facilities, billing vendors, IDR representatives, and sometimes even stop-loss carriers. The NSA did not end reimbursement disputes. It just simply changed the forum, the leverage points, and created new procedural legal issues. And from a recovery perspective, once money starts moving through the new process, the next question is always the same. Was it owed? And was it paid correctly? And if it wasn't paid correctly, who has the right or obligation to recover it? Bryan, can you give us a little bit more of a refresher on the actual process?
Yeah, absolutely, Cindy. So as a refresher, when a claim is subject to the No Surprises Act, that patient's cost sharing is generally limited as if it were an item or service that were serviced in network. So the provider, the facility, like you said, they still have to resolve that remaining payment dispute with the group health plan. So the process generally has a few steps to it. The plan makes that initial payment or denial decision. The parties then may enter open negotiation. If that still remains unresolved at that point, then either side can initiate the IDR process, and then they submit payment offers. Each side submits one, and then the certified IDR entity selects one of those two offers. So that ultimately becomes the payment determination. So you can see it's a lot like the arbitration style used in baseball. And CMS expects that to be the mechanism for resolving those kinds of out-of-network payment disputes between providers and facilities and plans and issuers. So for self-funded plans, obviously this process can directly affect a host of things, plan assets, claim spend, stop-loss reimbursement, certainly, reserve projections, and even ultimate vendor accountability here. So when you hear about this process design, it probably does feel pretty similar to the subrogation and recovery world that you're operating in day to day. So I think part of, before we get to the future, the current caseload that's payer side, I think it does make sense to talk about the previous cases from the first wave of litigation. That first major wave was mostly provider or physician side instead, and they were challenging the federal agency's rules for the IDR process. And those, we affectionately call them the TMA cases. That stands for Texas Medical Association. There were 4 cases, so they're just TMA 1 through 4 when everyone kind of talks about them. But those are your key examples because they show how the agencies were being initially challenged, especially when it comes to the role of the qualifying payment amount, or what we call a QPA, which is part of that IDR process. The QPA matters because it's generally tied to the plan's median contracted rate for a comparable item or service. And providers had argued in the first 3 TMA cases that if IDR entities were pushed too heavily towards weighing the QPA, then the process wouldn't really reflect the full range of what Congress had intended when they created this requirement. So that was their core argument there. TMA4 was a little different. They challenged some of the administrative fees and the batching rules that were part of the process too. But now we know from the way those cases came out and the DOL's subsequent guidance they issued through an FAQ, that the litigation continues to affect regulatory and enforcement landscape with this. And it's affected the agency's own post-litigation posture here with their guidance that they're issuing. So the TMA cases being largely provider side litigation against the government was that first genesis of cases. And now we're seeing this new wave of cases that's very focused on the payer side against providers, facilities, and even billing companies over alleged misuse of the IDR process. So I think they're being driven by 3 practical concerns. I think it makes sense to talk about all 3 of them: volume, award exposure, and eligibility concerns. The first is when you talk about volume, it's about federal IDR volume has been absolutely enormous. The CMS has recently reported that there were over 1 million disputes initiated during the first half of 2025 alone. And that's a 39% increase compared to the last 6 months of 2024. And CMS also reported that the top 10 initiating parties or their representatives accounted for almost 70% of those disputes in that period. So when you see a small number of parties or representatives and they're responsible for a very large share of the disputes, I think payers naturally are going to ask whether the process is being used as Congress intended or if it's some kind of revenue strategy. So I think that's the first part there. From an award exposure perspective, payers are concerned not merely with the number of disputes, but with the size of the awards and the relationship between awards, billed charges, those QPA amounts we talked about, historical reimbursement, and your market rates. Cindy, what do you think about the third one there with eligibility concerns?
Exposure and the volume are definitely some considerations. Another consideration that I don't know was initially as obvious is eligibility concerns. The payer side complaints tend to focus on whether the disputes were actually eligible for federal IDR in the first place. Like, common allegations include disputes allegedly governed by state law rather than federal IDR, failure to complete open negotiations, untimely initiation, non-covered or improperly characterized services, inaccurate portal attestations, inflated payment demands, or mass filings or batching strategies. They're allegedly overwhelming payors and IDR entities. And we're going to talk more about that here briefly in just a moment. But this is when I'm a recovery attorney. So I'm typically on the subrogation side, but these kind of all make my ears perk up because I'm hearing a lot about the same issues sometimes that we have on the subrogation side. Concerns about eligibility, documentation, and procedural leverage. Many of the same things that are in my subrogation world are what we're talking about in the overpayment recovery in the IDR process. The issue is often whether the legal and factual prerequisites for recovery actually exist. The payor in theory in these cases is that certain IDR representatives or relative provider entities allegedly use the IDR process at scale in ways that they payors believe were improper, including pursuing disputes the payor contends were ineligible or unsupported. These cases are not just about one disputed claim. Instead, they challenge an alleged business model. So when we were talking sometimes about, we're going to talk more in detail about what those business models could be. But that's something that we're seeing is emerging from these disputes. They raise questions about who is driving the IDR strategy. Is it the provider? Is it a billing company, a revenue cycle vendor, a litigation recovery entity, or an IDR representative? They also raise the question of whether payors can obtain judicial relief when the NSA itself provides a specialized IDR process. Essentially, who has the ultimate oversight of this process? And in subrogation, we often see disputes whether a recovery vendor is properly asserting its rights on behalf of a health plan. Here, we're seeing a very similar structural issue from the other side. Who is asserting the payment demand and on what authority and with what documentation? These cases do show that payors are increasingly willing to challenge what they view as systematic, high volume, procedurally defective use of the process. I want to talk a little bit about a case that I think exemplifies in what we're talking about, and it shows the evolution. So, Bryan initially was talking about how when the No Surprises Act came out, a lot of the litigation surrounded the provider side. So the providers had issues with the process. And now it's kind of evolving, like we just talked about, into the payor side. And a very good example of that is a recent case, Anthem versus Halo MD. In this case, it's a California case, and it's especially important because it produces an early ruling, and that ruling was really not favorable to the payor. The complaint alleged that Halo MD affiliated providers and related entities engaged in a coordinated scheme to submit ineligible IDR disputes, make false eligibility attestations, and obtain inflated awards. The claims included RICO, fraud, ERISA equitable relief, unfair business practices theories, and requests to vacate IDR awards. The final judgment was entered on April 9th, 2026, and we're recording this on May 7th. So not that long ago, but the court dismissed the vacator claims with prejudice and dismissed the remaining claims for lack of subject matter. So basically the court said, this is not us. We can't rule on this case because there is a very clear system that has been set up by Congress. It's not for the courts to decide. The California decision is really important, and it should not be overstated. The court's dismissal was largely about whether the federal court had authority to hear these claims and whether the claims could proceed as pled. It's not necessarily a broad merits determination blessing every disputed IDR filing practice. A decision on the merits of whether fraud occurred was not reached. The court held simply it lacked authority to adjudicate the claims under the congressionally created and structure of the IDR process. The California Halo MD dismissal is a reminder that payors face a difficult threshold question. Even if they believe the IDR process has been misused, can they get the federal courts to review the conduct after IDR determination has been issued? This is not the same thing as saying the alleged conduct is good, bad, or fully resolved on the merits. From a recovery perspective, that is a familiar problem. You may believe money was paid improperly, but the first question is whether you have the right procedural vehicle to get it back. Bryan, I know that we have another case that you wanted to talk about that I would be thrilled to hear more about.
Yeah, there's actually several cases here that are still in some measure ongoing or may have just been resolved too that I think are really important here. And these cases also involve payors suing either providers, facilities, or billing companies. So the first one is Anthem versus Prime Healthcare. That's another California-based lawsuit here. They're alleging that Prime Healthcare's hospitals misused the NSA arbitration process to attempt to obtain higher out-of-network payments. And they're saying that they did so by submitting ineligible claims and quote unquote knowingly flooding the IDR system with those claims. A lot of the cases that we're going to talk about today have similar allegations to them. There's usually allegations that implicate whatever state law is potentially in play. In this case, it would be California, ERISA, um, the NSA, obviously. This case is still in the very early stages, but it does showcase the question of whether hospital systems and facilities are likely to increasingly get dragged into this litigation where payers are trying to argue that claims are ineligible or improper to begin with. Um, the next case is Blue Cross Blue Shield of Texas versus Zotec Partners, and that was filed late last year, but it's still ongoing now. This one's interesting because instead of a payer going after a provider or a facility, it involves a billing and revenue cycle company instead. So this is a lot about the infrastructure behind large-scale IDR activity. So Blue Cross is alleging a lot of the same things here, that Zotec submitted false information, ignored applicable state law, violated the IDR timelines, and disregarded eligibility parameters in order to try and get those higher out-of-network payments. And they also alleged that there was a batching issue here in an attempt to overwhelm Blue Cross by submitting each batch with 66 unique items or services on average. So it made it harder for them to comb through those. So similar to the other one, you have allegations of fraud, fraudulent inducement, even unjust enrichment here. In this case, highlights I think for self-funded plans, really, that they need to understand who's controlling their IDR submissions, how eligibility is being reviewed, and whether claim administrators have sufficient reporting and escalation procedures in place, and even if they have the appropriate manpower in place to handle this IDR process if they're consistently alleging that they're being overwhelmed. The last case I'll talk about before I send it back over to you is this one called Aetna versus Radiology Partners. And I thought the fact pattern there was kind of interesting. There was a local radiology affiliate known as Morey, Bean and Brooks. We'll just use MBB for short here. They had an existing Aetna contract at the time, and Aetna's allegations against Radiology Partners involved the IDR process after MBB was acquired by Radiology Partners. So Aetna effectively alleges it happened in phases. The first was post-acquisition. Radiology Partners caused services performed by other affiliated radiology groups that they own, that they had separate in-network contracts with Aetna with, to be billed under MBB's tax identification number instead in an attempt to boost those rates because it was a more favorable contract. And then the second phase is after Aetna decided to term their contract with MBB, Radiology Partners continued to bill those services using that same tax identification number, and then initiated tens of thousands of NSA claims as a result. So that IDR piece here is Aetna effectively alleging these claims are pushed into arbitration as if they were proper out-of-network claims, but Aetna saying that they're not. So this led to a litany of allegations, as you can imagine, everything from false certifications of eligibility, inflated charge histories, abusive batching, but also some more interesting ones here like tortious interference and negligent misrepresentation, and even civil conspiracy. So they really threw everything at him here. And Aetna also sought to vacate the arbitration awards and sought injunctive relief, but I thought it was really interesting how the court dealt with this, because the court accepted a lot of these allegations from Aetna, but like we saw with the first case you talked about, this was dismissed because the court held that there were limited grounds for judicial review here for NSA claims due to that existing NSA structure that Congress put in place. So these legal theories vary, but I think the common payer concern is the same. The IDR process may be creating opportunities for some different reimbursement strategies here that are very difficult to police on a claim-by-claim basis. So I know we have one more case to talk about, and the fact pattern here is pretty extreme, so I think Cindy is going to enjoy walking you through this one.
Yeah. So we're talking about different, you mentioned different strategies for reimbursement, which is, I think the next case is going to be pretty interesting and exemplify what we're talking about here. The case that we're going to talk about next is called the Emblem Health versus Norman Rowe MD case, and this is a new case. It just was recently filed, but what was interesting about this, it's the facts, and it kind of is an interesting one, to say the least. So, what happened here? The allegations are Emblem alleges that Dr. Rowe began performing surgeries at hospitals that were in network for the network to trigger the NSA's payment dispute protections. So, Emblem alleges that it was planned that this is how these pre-scheduled surgeries were going to occur. And they also allege that there was a failure to provide or obtain NSA notice and consent forms. They also, another allegation is fictitious or non-market billed charges and separate IDR submissions for primary and assistant surgeons. In addition, the IDR award, and this is what's most interesting. The IDR award was $440,000 for procedures that are historically reimbursed far lower, more like the $6,000 to $30,000 range. And that is very raised a lot of eyebrows. $440,000 was the award versus what would a plan would expect to be somewhere in the $6,000 to $30,000 range. That's a pretty significant difference.
Massive.
This is very early in the complaint stage, but it's very interesting. Did you have a beyond your eyebrows raising over there, Bryan? What were your thoughts on that?
Yeah, I think it's a little alarming for plans to hear numbers like that get thrown around, especially over several different claims where they had similar results. He was performing these allegedly in a network facility, but he himself was remaining out of network. So that's where the rub happened here. But it does seem like it's a really big problem for plans and payers to have to worry about. If these awards are coming down afterwards, the plan may be responsible for a significantly larger payment than initially anticipated or even budgeted for.
Yeah, and it's kind of takes some of the if you were a provider, it takes away quite a bit of the motivation to join some of these networks.
Right.
All right. So, what matters for our purposes here is that this case shows why payers are so concerned that the IDR process can produce very large awards and why they are looking for judicial tools to challenge awards they view as unsupportive, excessive, or procedurally defective. At a practical level, these payer side cases can be understood as efforts to test whether the adequate protections exist within or alongside the NSA's IDR structure to prevent self funded plan assets from being used to pay awards that the payer alleges were generated through ineligible, inaccurate, or procedurally deficient IDR submissions. Bryan, can you tell me a little bit more? Can the courts even hear these cases? Because that's really so far what we've seen is the courts are saying, no, this is not us. This is go back to your process. And I know I've said this before, but that's what we're seeing procedurally is an issue. That the courts just won't hear it.
Right. Yeah. I mean, the payer side cases here raise good questions about jurisdiction and judicial review and whether parties can even use these kinds of legal theories to attempt to attack IDR conduct or even the awards. So the threshold question really is, will federal courts be willing to entertain these theories at all? Or are they just going to view them as impermissible attacks on the IDR process? I think in recovery litigation, having a compelling factual story oftentimes isn't enough, right? You need that jurisdiction, a cause of action, standing. Everything needs to be done timely. And you also really importantly need a remedy the court's willing to provide and enforce. And here that's, I think, what payers are trying to establish with this wave of cases, but they just haven't had a lot of luck early on, as you can see, especially when it deals with eligibility or fraud. They expect that the courts rather expect that to be raised in the IDR process itself whenever possible. So you need to, if you have those eligibility objections or fraud concerns, identify them early and preserve them early. It's really a good chance for your plan documents, your ASA or ASO agreements, your vendor contracts, making sure your recovery authority, making sure that's all aligned becomes really critical here, because if the plan is ultimately funding this claim, it needs to know who's monitoring these things in case there is fraud, waste, or abuse. And I think that probably brings us right to our biggest takeaways for self-funded plans and TPAs here. Um, the the biggest one being that this is a real financial and governance problem for plans. And when we were prepping for this webinar, you used the term that I really liked, circle of responsibility. Like, who owns this? I think that's great. The plan should know who handles the IDR disputes for them, who decides whether to challenge eligibility in the first place, who's determining what the plan might offer as a potential award, who's tracking those award amounts. Like, the list goes on, including how stop loss gets involved here. So I think this needs to be treated as something that's not purely a vendor function. Like, this, a self-funded plan needs to have a pretty involved role here, because this can be a direct plan cost issue. It can be a vendor governance issue between you and your vendors. Certainly on a stop loss side, that's a concern, and it might even raise the level of fiduciary oversight. So um, there's a lot of things to look at here, and identifying the parties responsible for monitoring it or putting those methods in place so it can be done going forward. Reviewing your contracts, look through all of that, and definitely make sure how you know how IDR outcomes are going to impact your stop loss claims, and confirm with your carrier if these kind of high outcome results are going to be subject to lasering or exclusions. The plan, I don't think, wants to be on the hook for one of those $440,000 determinations if they can avoid it. That could be catastrophic for a lot of people. So trying to avoid being caught off guard, because the judicial system here has been certainly reticent to change the IDR process or walk back these awards. They want plans to use that process effectively. So, like you said, building that circle of responsibility, key, I think, to making sure that concerns are raised before or during the process rather than post-award. If plans want to wait and risk that, I think at that point it might be too late from what we're seeing here.
Yeah. And when I think of the circle of responsibility, for me, I like to know where does it what am I holding, and what do I have to know? And if I'm supposed to be on top of these things, you need, as a plan, to make sure that you are working with the vendor, and make sure that you're working with your everyone, and to understand what is going on. And instead of uh waiting for it to just resolve on its own, I'd call up the FIA group and give us a call and see if we can't help you with these. I do want to say that, in closing, the No Surprises Act, it did what it was supposed to do, in that it took the patient out of it, but it really didn't remove the billing disputes. And now the newer wave of these cases is a little different. It's on the payer side, and now the payers are testing whether they can use litigation to challenge alleged misuse of the IDR process. They want to recover payments or prevent enforcement of awards that they believe were improperly obtained. Those cases are still developing, and some of the early rulings are showing that payers may face significant procedural hurdles. The broader governance lesson here is very clear. Self-funded plans, TPAs, and vendors need to understand how IDR disputes are being handled, who are controlling the strategy, and how those outcomes affect plan assets. So, Bryan, what we've learned is there is a lot of surprises with the No Surprises Act.
It's a good way to put it. And while these cases are working their way through the courts, I would suggest that plans and their TPAs don't sit on these things, and try to find the time that it's going to take to look through these, even if there are huge batches of them. Trying to find the time and the resources to go through them, so that way they don't get to the award stage and it might be too late to do anything about it at that point.
Well, thank you, Bryan. And I think this was a very good topic to discuss, and very timely. So I hope that those listeners agree. So thank you for joining us for another episode of Empowering Plans with the FIA Group.
Thanks, everyone.